We move to the second part of the evening, which is the book launch. And with this, ladies and gentlemen, we will first have the introduction of the book by Miss Kula Simsom. Kula? Oh, okay, the floor is yours, madam.
Well, the pressure. Good evening, ladies and gentlemen, all distinguished guests, and all protocols observed. Tonight, yet again, we celebrate a milestone of Mr. Namandje for the launch of his book, The Lawyer's Place in Society and the Professional Secrecy Through Case Law. Now, there are several disclaimers that this book has already been read. My colleagues that have read, let's pretend you have no idea what's going on, as I'm about to outline to you what this book is all about. I'm actually really excited to listen to Judge Moseneke to outline really the principalities and the importance on not only the concept of confidentiality, but as well as the attitude of our courts insofar as balancing the interests for society. Now, this book covers fundamental jurisprudence on confidentiality, often misconstrued or underestimated. It is with certainty a refresher in an era where lawyers are often labeled the worst people in society for covering criminals, they say. All lawyers are liars. This book was authored with lawyers and legal practitioners in mind as the custodians for the rule of law and because of the noble role we play in society, but in particular the classified role with respect to matters concerning professional secrecy, known as your attorney-owned client confidentiality and privilege. It is the author's view that professional secrecy can only be achieved and maintained once the practitioner has a thorough understanding of the legal principles on attorney-owned client confidentiality and privilege, the rights derived from such privilege, and the reasonable limitations to such rights, which in this context, a practitioner then has the role to convey to a client what such privilege may entail, the characteristics of the privilege, when it may be waived or raised on behalf of a client in the general administration of justice. However, at the same time, the book recognizes that environment to exist between themselves and a client for an open, frank, and unhindered disclosure of facts and materials by the client to the lawyer. Now, in terms of the structure of the book, the author introduces a legal framework in terms of the constitutional expectation that derives or that sort of protects the confidentiality aspect. And in this instance, it's the right to privacy, which is a substantive rule of law. Now, the reason for stating this is there's a general attitude that it should, in fact, be absolute. However, our Constitution provides limitations to these fundamental rules, provided it meets the reasonableness test in terms of your Article 21 and 22 of the Namibian Constitution. This is, of course, very closely related to your reasonableness test in terms of administration law. Now, one can appreciate this book as for the longest time, we've made use to a lot of the South African precedents, the books of Hoekstra and the likes, but now we have a local edition to sort of set great precedents for us on what our position is in Namibia. Now, insofar as attorney-owned client confidentiality is concerned, the author at length expands through case law the legal principles that apply to confidentiality. For instance, the confidential communication to whom it's made, the information provided, as well as the need to retain such confidence. Now, yes, the book, of course, recognizes the common law position as well as the constitutional position, but it also further extends to explain on other statutory requirements that then become applicable when you're dealing with the question of confidentiality. For instance, the aspects on Financial Intelligence Act that deals with concerns on confidential information. Now, the aspect on privilege, characteristics of privilege have also been highlighted to the extent that it speaks on a right that a client may assert to prevent the disclosure of information and as well as the part that the lawyer must remain confidential. Perhaps this is, of course, the reason why society generally has an understanding that lawyers are liars because of what they need to maintain in confidence, which is, of course, not the case. But I hope that has now been clarified. Pardon me, I just lost myself there. Yes. Now, of course, to state further, what the author then intends to achieve in the book is that he further goes to insert the limitations, and he goes at length to explain how the operation of limitations work. For instance, it makes mention that a right may be limited in that a client is not prohibited from seeking relief to prevent publication of confidential information. So any relief that is sought from court to protect any form of confidential information requires a balance of competing values. This is where the author tries to break down the constitutional limitations test and therefore the domestic and selected jurisdiction court's attitude in the determination of these limitations. So really what the author is voicing in this book to an extent is that for attorney-owned client to be used as protection against forced disclosure, it must be clear that such a disclosure or a use of such protection must be subject to legitimate interference of limitations and restrictions that are necessary and in accordance with law, rather for the interest of the general public. And now, one particular case that the author directs us to is the Namibian case, Africa Personal Services versus the Government of the Republic of Namibia. Pardon me, the citation is in the book, wherein the author explains the stages in which the court determines this limitations inquiry. One, whether the disclosure limits the exercise of fundamental freedoms to the client, and if so, to what extent the limitation is applied, and lastly, whether that limitation is constitutional. Where the answer is for one in the negative, that the limitation is permissible, but it is disproportionate to the limitation, or rather the limitations or the requirements provided in Article 21.22 or 4 unconstitutional and becomes unenforceable. Now, ultimately, the court must be satisfied that each criterion has been satisfied. Again, the author then further extends and explains the comparable limitation clauses in other jurisdictions such as South Africa and Canada. Now, lastly, the theme that can really be recognized is that in this book is that the proportionality test will always vary depending on the circumstances, and it will always be on a case-to-case basis, and that it will be required that there will be a test for balance between the general public and those of individuals. So, in my view, the author has certainly achieved to set out the position in our domestic courts and foreign jurisdictions in relation to legal principles on attorney-owned client confidentiality and privilege, and the competing discussions on the characteristics of privilege and waiver on attorney-owned client confidentiality. I hope this talk has encouraged you to purchase the book tonight. It is available at the foyer, alternatively during business hours, and also at Book Den. And if you can't find it, arrangements can be made. All right, thank you.